It is our role to review that decision and only interfere with it if we identify a flaw or flaws in the judge's treatment of the question to be decided, such as an error of law, a gap in logic, or a failure to take account of some material factor which undermines the cogency of the conclusion. We conclude that the judge made a number of errors of principle which undermine his decision. We were told by counsel for Epping that the protests operated as a trigger for the application for the injunction. The fact of protests outside a building is not obviously a matter falling within planning control. While we accept that the judge was right to exercise considerable caution before attaching weight to the fact of the protests, including unlawful protests, outside the hotel, he nonetheless gave weight in his evaluation to the fact that protests were occurring and weighed them in the balance as a factor in favour of granting the injunction. These are worrying aspects of the judgment. If an outbreak of protests enhances the case for a planning injunction, this runs the risk of acting as an impetus or incentive for further protests, some of which may be disorderly, around asylum accommodation. At its worst, if even unlawful protests are to be treated as relevant, there is a risk of encouraging further lawlessness.